How long does a foreclosure take in Florida? Foreclosure is a legal process aimed at recovering the outstanding loan balance by selling the property used as collateral. This process can be a particularly challenging experience for homeowners in Florida, especially those who are unfamiliar with how foreclosure works. The length of a foreclosure procedure can depend on the complexity of the case and the actions of the lender. What is foreclosure? Foreclosure is a legal process wherein a mortgage lender or financial institution claims the ownership and possession of a property due to the borrower's inability to pay the outstanding mortgage debt. Generally, when a borrower defaults on their mortgage payments, lenders take legal action to recover the remaining balance of the loan. Foreclosure procedures vary by state, with some requiring the involvement of the court, while others do not. Judicial foreclosure process in Florida. The judicial foreclosure process in Florida typically follows these steps: complaint and summons, response, default judgment, summary judgment, final judgment, foreclosure auction, certificate of title and right of redemption. Types of foreclosures in Florida. There are various types of foreclosures in Florida based on the type of property, type of loan, or the process followed. The most common types of Florida foreclosures include residential foreclosures, commercial foreclosures, homeowners association (WA) foreclosures, tax deed sales. Florida foreclosure timeline. Florida is a judicial foreclosure state, meaning the foreclosure process must go through the court system. The foreclosure process can take anywhere from a few months to over a year, depending on various factors, such as the borrower's participation in the process, the court's availability, and other case-specific variables. Here is a general outline of the Florida foreclosure timeline. Pre-foreclosure phase, 30 to 120 days. In Florida, the pre-foreclosure phase generally begins when a borrower has failed to make mortgage payments for 30 days, and the lender decides to initiate the foreclosure process. Notice of default. The pre-foreclosure process officially begins when the lender files a notice of default, NOD, with the county recorder's office. Borrower's options. During the pre-foreclosure phase, borrowers can try to resolve the default in several ways. Loan reinstatement, loan modification, short sale, deed in lieu of foreclosure, right to redeem the property. The right of redemption is a statutory provision that allows the borrower to reclaim their property by paying the full amount owed on the mortgage, plus any additional costs and fees. Redemption period. The redemption period varies from state to state. Foreclosure judgment and sale, 2 to 6 months. Once the discovery phase ends, the lender will typically file a motion for summary judgment or set the case for trial. Deficiency judgments and eviction, 1 to 3 months. If the foreclosure sale does not fully satisfy the outstanding mortgage debt, the lender may have the option to seek a deficiency judgment against the borrower for the unpaid balance. Eviction process post-foreclosure. Once the redemption period expires and the new owner takes possession of the property, the borrower is no longer considered the legal owner and must vacate the premises. If the borrower refuses to leave, the new owner can initiate the eviction process. Notice to vacate. The new owner must provide the former homeowner with a notice to vacate, which typically gives the borrower about 30 days to leave the property. If the borrower fails to comply, the new owner can file an unlawful detainer lawsuit with the local court to obtain an eviction order. Court-ordered eviction. If the court approves the eviction order, the local sheriff or marshal will serve the notice to the borrower and carry out the eviction. The borrower will be given a final deadline to remove their belongings and leave the property. If the borrower fails to comply, the law enforcement officer will forcibly remove the borrower and their belongings from the property. Factors that can affect the duration of a foreclosure. The timeline aside, the length of time a foreclosure takes can also depend on a number of factors that may be separate from the judicial process and the process of foreclosure itself. In Florida, some additional factors that can affect how long a foreclosure can take are as follows. Economic conditions. The overall economic condition of a region or nation plays a significant role in the length of the foreclosure process. Bank and lender practices. The policies and procedures of the bank or mortgage lender involved in the foreclosure can also impact the length of the process. Homeowner actions. The actions of the homeowner facing foreclosure can also play a role in determining how long the process takes. Property condition and occupancy. The condition and occupancy status of the property can also affect the length of the foreclosure process. Complex legal procedures and litigation. The foreclosure process is characterized by intricate legal procedures, and navigating these complexities can be challenging for homeowners and lenders alike. Defenses and alternatives to foreclosure in Florida. Florida homeowners facing foreclosure have several options to defend against or postpone the process. These defenses and alternatives to foreclosure include loan modification, short sale, deed in lieu of foreclosure, bankruptcy, legal defenses, managing the foreclosure process. Managing the foreclosure process as a homeowner in Florida can be a daunting and complex task. However, with the right approach and understanding of the legal landscape, you can navigate the process more effectively. Here are some key steps to help you manage the foreclosure process in Florida. The role of the homeowner and lender. The foreclosure process is a complex procedure involving both the homeowner and the lender. Negotiations for loan modifications or short sales. One potential option for avoiding foreclosure is to negotiate a loan modification with the lender. Contact us today at 305-354-9313 to schedule a consultation with one of our attorneys.